What are reasons that your marriage-based green card application could be delayed or denied? That's what we're talking about on today's episode of Sumner School Family Immigration Basics. My name is Emily Sumner with Sumner Immigration Law. Before we get into the specifics, keep in mind that in this particular video, we're talking about the situation where you're filing the I-130 petition and the I-485 at the same time. That's often called a one-step. So you're submitting those forms and the other required supporting forms and documentation all together at the same time with USCIS. So clients often ask me, and it's a great question, what are some reasons that my marriage-based green card application could be delayed or denied? We can't cover every single possible reason in this video, but here are some of the more common ones. The first one is documentation, either required supporting documentation that is missing, that wasn't included at all, that is incomplete, you submitted some of it, but not nearly enough, or documentation that is just incorrect. So for example, an incorrect version of a marriage certificate or a divorce decree, things like that. The second reason that your case, or a possible second reason your case could be delayed or denied, is insufficient or harmful documentation of your relationship. So one of the key elements of a marriage-based green card filing is showing that you have what's called a bona fide relationship. That means that this marriage is a true marriage and it's not just for purposes of a green card filing. I often see people who have filed on their own and they have requests for evidence or even denials. And one of the reasons for that, or a reason for that, can be because they didn't submit that documentation at all, or they didn't submit nearly enough of it. Sometimes I will see situations where they have submitted documentation, but it's actually harmful. It has information in it that's harmful to their particular application. So that's another reason your case could be denied or delayed. In addition, it could be denied or delayed because there are errors on the forms. So if you have looked into this at all, you know that there are a number of different forms that need to be submitted. Some are optional, some are absolutely required. And those forms are long and they are complicated and there are so many questions on them, so many boxes that you have to mark correctly. If you mark one of those boxes incorrectly or put incorrect information on the form or fail to disclose certain information, that can cause the denial of your case or the delay of processing. In addition, another reason that your case could be delayed or denied is the affidavit of support. That is one of the most complicated forms that we deal with in my practice in US immigration law. It is complicated. So if you're having trouble with it, it is okay. We are here to help, of course, but it is complicated. There are really detailed regulations surrounding it. You look at a word and you think you know the definition of the word, but actually it's clearly defined in the regulations as something that you might not necessarily think of. So it's tricky, and the financial documentation can be tricky. That is something that we see often is a problem with people who have filed on their own and have cases delayed or denied because of that. Another reason is not responding to requests for evidence. And this seems silly. You might think, yes, Emily, if we receive a request for evidence, also called an RFE, you have to respond. But there's so many times that I have seen people come to me, prospective clients or clients come to me who have filed on their own, and for whatever reason, they did not respond to the request for evidence, or they responded and they responded improperly. So when USCIS sends a request for evidence, they use templates. Now it's possible that they're using AI to write these requests for evidence, so it's not always clear exactly what they're asking for. When we receive a request for evidence for our clients, we interpret what it means for them. We will send them the request for evidence that was received and then interpret for them exactly the documentation that we need to respond to whatever the concern is. So it's not easy to issue spot exactly what they're asking for and come up with a strategy to specifically address that. Some RFEs are easy, but a lot of them are not so straightforward. Other reasons that you may not respond to a request for evidence are sometimes clients generally don't know, or prospective clients generally do not know that they have to respond to it. Other times they respond and USCIS says they didn't receive it. Other times the client never received it, either because there was some sort of issue with the mail or with USCIS not having sent it, or because the client moved and didn't change their address. And when I say client, I really mean applicant, somebody who's filing on their own. But if you move and you don't update your address with USCIS, then you're not going to receive further documentation. And I've seen that happen before. And then finally, one of the common reasons that we see clients or prospective clients who come to us and have previously tried to file on their own have denials is because of a criminal history or an immigration history, a problem, a complicated problem, complicated immigration history. And it may not even seem complicated to you. It may just seem like, oh yeah, I had that happen in the past, but it's actually a problem for the filing. Same thing with criminal histories. I talk to prospective clients all the time who then ultimately become our clients, and they say, oh, no, I don't have a criminal history, and I ask more questions, and it turns out that they have charges that were expunged or dismissed, and we actually do have to disclose them. Sometimes they're problems, sometimes they're not. But if you don't disclose them at all, that can cause tremendous problems down the road. So these are just some of the reasons that a case may be delayed or denied. There, of course, are others. In our practice, we are absolutely here to help our clients. So as you hopefully know, if you're a client of Sumner Immigration Law, we have detailed checklists that we give to clients to make sure that we're providing all the information that they need so that they can get us the information that we need, all of the supporting documentation. But we take it a step further than that. We analyze the documentation, make sure that it is the correct documentation. We have quality assurance checklists to make sure that we're completing all of the forms and boxes and everything correctly. And once we receive documentation from clients, there's more work to be done. We have to analyze it and see, is this actually going to be helpful for their particular case? Or is it something that we really shouldn't submit? You don't want to over document the case. You don't want to include information that's going to be harmful. So there's a lot of analysis that goes into it. It's not simply completing a checklist and submitting the documentation. I hope that you have found this video helpful. If so, I hope you'll share this video with a family member or friend, and make sure that you are subscribed to our YouTube channel so you don't miss our next videos. My name is Emily Sumner with Sumner Immigration Law. We serve clients with family-based and employment-based immigration matters around the United States and around the world, and we would love to help you next. If you have a question, put it in the comment. We will answer if we can. We can't give legal advice through these videos or through comments, but feel free to set a time for a consultation, and we would love to see how we can help. Until next time, my name is Emily Sumner.